This program contains scenes with strong language and may contain violence. Viewer discretion is advised.
All rise.
Court's in session.
All rise for the Honorable Judge Jason O'Neill.
Alright, so the matter we have before us today is going to be the matter of R versus Hillenbrand. This is trial date. And the charges that you're going to be facing are going to all be indictments. Charge 1, careless use of a firearm. Contravention of storage regulations. Pointing a firearm. Possession of prohibited or restricted firearm with ammunition. Assault with a weapon or causing bodily harm. Murder reduced to manslaughter. And Crown Counsel, I'm going to be dismissing the charge of use of a firearm in commission of an offense, as this is a conflicting charge.
Okay, that sounds good, Your Honor.
Alright, are both parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Alright, Crown Counsel, I will leave it to you for opening statements.
Alright, so... This case that we got before us here, kind of shows the road of a reckless act of heroism there, from a off-duty OPP officer, and, the blatant disregard for safety within the public eye there. That's all I've got for an opening statement there, Your Honor.
Alright, Defense Counsel, you may present your opening statement.
Thank you, Your Honor, and good evening and welcome to all. Thank you for coming down here today. I'd like to begin by saying that I agree with one aspect of my friend the Crown's opening statement there, and that this was an act of heroism. My client was acting as an off-duty officer. He heard gunshots, and instead of waiting and seeing what would happen in the aftermath, he decided to rush in and save public life. There was no other injuries that day other than was acting in the best interest of society and his community and using his training, and that he is not the criminal that the Crown is trying to paint him.
Alright, Crown Counsel, you may call your first witness.
Your Honor, I'm going to call Provincial Constable Fanusin up to the stand.
Good evening, Your Honor.
Good evening, you may have a seat there, sir.
Alright, Provincial Constable Fanusin.
Yep.
If you could look at Article A in the evidence there, you see the handgun in the evidence bag?
Yep,
All right. Is that the firearm there that you seen on Jay Hillenbrand that night?
that is yes.
Okay. Did you conduct a GSR test on Mr. Hillenbrand, or was it a verbal confirmation that he fired the weapon?
The GSR test was conducted by one of the supervisors on scene. I was there as the first officer on scene, which only heard audible signals of shots being fired from within the store.
Okay. When you guys arrived, did you arrive almost immediately after the shots, or was there some time passed between the shots and you showing up?
There were actually shots being fired as I arrived on scene.
Okay. Did you see the accused attempt any sort of life-saving measures before you guys were on scene there?
Well, I didn't see anything before we were on scene, but after we arrived on scene, I witnessed the Mr. Hillenbrand over there had his firearm pointed at a dead body near the counter inside the store.
Okay. So it's safe to assume that there was no life-saving measures that were attempted by Mr. Hillenbrand?
Your Honor.
Yes, did you have an objection?
Yes, I don't believe the officer can state that the body was deceased at that moment in time, just based on his observations by arriving at the scene. I just wish for that to be stricken from the record.
Well, yeah, there was a body unconscious individual on the floor there, while Hillenbrand was had his firearm pointed at the unconscious individual. The individual was on the ground near the counter, and I did not see any sort of first aid or life-saving measures as I arrived on scene.
Okay. When you searched the body of the individual that was unconscious there, did you find any sort of firearm or weapon on him?
It was not me who searched the individual.
Okay. That's all I have, Your Honor.
All right, thank you, Constable. You may step down.
Thank you, Your Honor.
My apologies. It's been a long day. Defense, do you have any questions for the witness?
Oh, Faunison, you gotta go sit back up there.
Not at this time, Your Honor.
All right. My apologies, Constable. You may now step down.
Thank you, Your Honor.
Crown Counsel, your next witness.
My next witness is going to be Chief Superintendent M. Brandon.
Good evening, Judge.
Good evening, Chief Superintendent. You may have a seat there.
All right. So my first question for you there, Chief Superintendent, is whenabouts did you arrive on scene for the call there?
Just a minute.
Yeah, no worries.
That look okay?
Oh, you're a little crooked on the chair there, sir. If you try standing more like towards the middle of it.
If we could turn up the speakers there for the folks in the back of the courtroom, please. Is everyone able to hear me in the back there?
Yeah.
Yes, Your Honor.
All right. Chief Superintendent.
Yes.
What time did you arrive on scene at the call there? What time in the aspect of like the timeline of the event?
I don't remember the exact time, but I can't remember. It was probably around the afternoon.
Okay. When you arrived on scene, did you witness Mr. Hillenbrand with his firearm out?
Um, I I can't say I didn't know.
Okay. Is it true that in the course of questioning Mr. Hillenbrand there, he was giving several different stories? The body cam that you had submitted that that should be sent to the court here. It should be on the way to you there, Your Honor.
I can't recall that the story of the firearm did change a few times.
Okay. Do you mind telling to the court here the different variations of the firearm that was described by Mr. Hillenbrand?
Believe the first story that it was his service weapon, and then it turned to be a personal weapon.
Okay. Now, my memory doesn't serve me the greatest as for what your armament is there, but is it true or untrue that the OPP carry the Smith & Wesson Model 5904?
I believe that's untrue.
Okay. To go along with that there, Chief Superintendent, did the OPP get to take home their service pistols, or are they handed in at the end of the day?
Those are handed at the station. They are not to be used while off duty. That is a strict violation of a policy.
Okay. All right. I believe that's going to be it for Chief Superintendent there, Your Honor. Unless defense has anything for him.
I do.
All right, defense, do you have any questions?
Yes, Your
All
Honor.
right, you may proceed.
Chief Superintendent, how are you doing today?
Doing good, sir. Doing sir. Good evening. How you doing?
Oh, I'm not so bad. Just a couple of questions here. Were you the only supervisor on scene that night?
No, I was not.
Gotcha. Are there any supervisors here in this courtroom that were present that night?
Um, not that I can call right now. No.
Right on. So far, I have heard that was there was no one who had searched the subject who was pronounced deceased there to see if they had a weapon. Is that common procedure to not search a subject that was involved in a robbery?
The subject was searched.
Okay. And was the subject found to have a weapon on him?
Give me a minute. Give me a minute here. I'll have to refresh my memory here.
So you didn't search subject yourself?
At this time, I cannot recall. I'll have to I'll have to relook at my body cam evidence that I have here. If you could just give me 2 minutes, Your Honor.
Would we like to take a recess?
I would be amenable to taking a recess if I could have a couple moments audience with the Crown.
I'll be amenable to that.
All right, court will be in a 5-minute recess. We'll reconvene in 5 minutes, everyone. Chief Superintendent, you are free to step down at this time. Thank you.
So let me lower my projection. All right, I set it to 5.
All rise. The Honorable Judge Jason O'Neill.
All right. Court is going to be back in session at this time. Defense, would you like to continue with your cross-examination of Chief Superintendent Brandon?
We would, Your Honor.
All right, at this time I'll ask the Chief Superintendent to come back up to the witness stand. Thank you, sir.
Hello, Judge.
Hello again, Chief Superintendent Brandon. Hope you had enough time there to review your notes and your body cam footage.
Yes. Unfortunately, though, my body cam didn't start recording until I walked outside of the store. And that was before the questioning of Hillenbrand was conducted.
Right on. So just before, did being one of the supervisors on scene, did you review any of the officers' reports, or verbally did you have any officers report to you the findings of the items found on the deceased male from inside the store?
Well, I believe that this male definitely did have a firearm with him, and I believe he also did have a wallet.
Do you know who would have told you this information? Which officer?
Well, obviously, there was a shooting, and when as around the scene, there were gunshots going on back and forth. So it was obvious that two weapons, at least two weapons were involved.
No, I absolutely can appreciate the act of needing to make quick decisions that may or may not have been right in the moment, especially when there's gunfire going off like that. I think my client can also appreciate that, which is why he finds himself in this predicament today. So the only reason I'm asking you these questions, Chief Superintendent, is that, like I stated earlier, I failed to see any work from the Ontario Provincial Police or the Royal Canadian Mounted Police that shows that the subject inside did or did not have a weapon on him. Like we are aware that my client did have a weapon on him. He is an officer of the law, and he responded to.
Sir, I wasn't referring to a client. I was referring to the victim.
No, and that's what I was getting to. We know what my client had, but we don't know what the in quotes victim had. I believe my client was a victim, not the person deceased. I believe he shot the person there, which is undisputed by all parties here, in an attempt to save public life. And being a supervisor on scene, with my questions here, I was hoping that you would have the information that would prove this different.
So the thing is, I wasn't the first resident scene.
Okay, do you know who was?
I do not know.
Okay. That'll be all, Your Honor.
All right. Chief Superintendent, thank you for your time here. You may step down.
I do have one thing I want to say.
Yes, sir.
You know what? You know what? I'll just say it for the end.
All right, sir. Thank you for your service. Crown Counsel, do you have any more witnesses to call?
Yes, Your Honor. At this time, I'd like to call the lead RCMP investigator up to the stand.
No, you're fine. You're fine. You're fine. Let's go stand. Thank you.
All right, sir. Now, would you be able to state your name for the record, please?
Yes, Your Honor. I'm Sergeant Robert Stanton with the RCMP. I've been an officer with the RCMP for 6.5 years now, out of the O Division of Toronto.
All right. You may have a seat, sir.
Mr. Stanton.
Yes, sir.
At the time of your investigation, did you pull any CCTV footage from the inside of the building?
Yes, sir. I collected CCTV of the liquor store. Had 2 cameras inside, one in the height strip and one that was kind of facing the counter area.
Would you be able to recount for me what you had seen on the CCTV footage there?
Yes, sir. It was my observation as the deceased subject entered the store, pulled a silver in color firearm on the clerk. There's no audio in the CCTV. The subject discharged his firearm once. About 30 seconds later, you could see Constable Hillenbrand enter the store with his firearm and discharge his firearm 3 times. The subject going down. Moments later, you could see OPP officers enter the store.
In the course of him entering the store and discharging his firearm, could you see any indication that he identified himself as a police officer?
It can be seen that he did say something. However, like I mentioned, there is no audio to that CCTV.
Okay. Was there CCTV angles outside the building as well?
We were not able to obtain anything.
Okay.
From any adjacent businesses that provided anything of interest.
Throughout the course of your investigation, did you recover shell casings at all?
Yes, we recovered shell casings that matched the gun found behind the counter of the store, as well as the gun taken off Constable Hillenbrand. The forensics was able to match both those weapons.
Okay.
For a total of 5 shell casings.
The silver pistol you found behind the counter, that can be accounted for as the subject of the robbery?
Yes, sir.
Okay. I have no further questions at this time, Your Honor.
All right. Defense Counsel, do you have any questions for the witness?
Not at this time, Your Honor.
All right. Sergeant, thank you for your time. You may step down, sir, and thank you for your service.
Thank Thank you.
Crown Counsel, your next witness.
My next witness that I'd like to call is Chief Superintendent Wild. I believe he should be walking into the building momentarily.
All right. Special Counsel, will we be able to page the Chief Superintendent?
I believe, Your Honor, that's him walking into the building right now.
Yes, Your Honor. Apologies for the tardiness. I was conducting a UC investigation I couldn't break away from. Deepest apologies.
All right, sir. Thank you very much. You may approach the stand, please.
Am I good to take a seat, Your Honor?
Yes, you are, sir.
Thank you.
Chief Superintendent.
Yes.
My first question here for you is it true or false that through the questioning of Constable Hillenbrand, you had received multiple different answers for the same question?
I can confirm in the line of questioning regarding various details of the incident that specific things changed 2 or 3 times in the course of questioning, yes.
Would you be able to recall for the court what those were?
One of the main ones was that first he was questioned as to using his service weapon. Then he had changed it to he was using a personal firearm that he was storing. In regards to that personal firearm, we asked him why he had it. He said he just keeps it in his car, and then he changed his story that he was on his way to a gun range to use it.
Did he state which gun range he was headed to with the firearm?
He did not.
Okay. Did you have any recollection or calls in the system regarding him transporting a firearm and making OPP, RCMP aware that the firearm would be moving?
I was not aware of it, and I was unable to search of any such record at the time.
Was anyone able to search his vehicle for the lock boxes containing the firearm and the ammunition?
I do believe it was searched. However, I was not the officer to search it.
Okay. At this time, Your Honor, I have no more questions for the Chief Superintendent.
All right. Defense Counsel, do you have any questions for the witness?
Yes, Your Honor.
All right, you may proceed.
Good evening, Chief Superintendent Wild. How are you doing tonight?
Fine, thank you.
Right on. So I just have a couple of questions here, just for some cleanup. You were there. You were present for the entire questioning of my client.
I was present on scene from right the beginning to the end of it when the RCMP came.
Right. So you were. So you had primary dealings with my client.
Not exclusively. However, just during the course of my duties and investigation, I was back and forth.
Perfect. Was my client read his rights and his caution?
Thank you.
Yes, sir, he was.
And what do you have about the time he was read those and if he stated he understood?
So at the time of the original gun, she was placed in detainment by OPP officers to begin their investigation. Through our investigation, the RCMP was contacted to start a third-party investigation to remain impartial in the case. As per our private discussions, we agreed that we would let Mr. Hillenbrand released from the scene, and he was met at OPP station at 3:43 in Aurelia to have a more private, less intrusive arrest, and at that time he was read his rights by the RCMP officers. I believe my notes show that also Staff Sergeant O'Neill was on scene, as well as Deputy Commissioner Steve Guile were also on scene as representatives, and they could attest to that as well.
All right. So just to confirm, my client, to the best of your knowledge, was not read his rights prior to making the statement that was on video that Constable Brandon would have been referring to when he was at the scene, and for the statements that you were referring to there, where he gave multiple different versions.
He was read his rights to counsel.
But he read his police caution, though.
I can't answer that. I wasn't present for it.
Right, because again, that's just one thing that I haven't heard yet today. So I'm just questioning the admissibility of that evidence, Your Honor.
I'd like to state that just because I didn't witness it doesn't mean it did not happen. I'm just simply stating that I can't confirm or deny that because I don't have the knowledge.
Well, if my friend the Crown would like to weigh in here, and if he does have that evidence of the caution being read.
No, I do not believe so. I believe the body camera there from Brandon appeared as he was being questioned, so I have no evidence proving whether or not the caution was read.
All right, and then just one last question here. Was the OPP involved in running the gunshot residue test on my client here, or is that handled by the SIU and/or the RCMP?
I believe a GSR test was done at the scene. That did come back as positive.
Do you have any recollection on which officer performed that test?
I do not know.
All right. That'll be all, Your Honor. No further questions.
All right, Chief Superintendent. Thank you for your time. You may
you're
step
welcome.
down. Thank you for your service.
May I address the court as well, or no?
Current counsel, do you have any issues with the Chief Superintendent making a statement?
I do not, Your Honor.
If we could have that, if we could just save that for the end. I think there might be other comments as well.
All right, would you be amenable to that, Chief Superintendent?
I can, yes. It's just a matter in regard to procedure, but I can save it till later.
All right, thank you, sir. Current counsel, do you have any further witnesses to call?
No, that'll be all for witnesses, Your Honor.
All right, defense counsel, do you have any witnesses to call?
No, Your Honor.
All right, we will move into closing statements then. Current counsel?
Well, Your Honor, throughout the road that this case has taken, I can see a off-duty OPP officer with a prohibited firearm making a reckless decision to run into a building where shots have been fired from, despite the heroism that was shown. And I will say that the heroism was there. It was definitely a reckless and rash decision to run into this building. It's caused a family some distress and possibly an unjust a loss of a family member that could have been thoroughly avoided by having on-duty officers arrive with They're registered, province-given firearms. And I really thoroughly do believe that it was a reckless idea to run into that building like that. Well, having 911 called, as well as the situation could have gone completely differently. He is trained in talking these situations down. And even when it comes down to self-defense, he injected himself into this situation where he needed a result to a firearm. And I do thoroughly believe that there could have been alternate routes taken and other procedures taken to avoid this situation from unfolding. And it's far beyond where a registered OPP officer should have gone, and resulted to in this kind of situation that I know is tense, but it's definitely not where it should have ended up. And really, in the end of the day, that's up to the on-duty marked official OPP officers to deal with. And in a sense, he would be more considered a citizen at that point, as opposed to a provincial constable, as he didn't have a badge on him, nor did he have any identifying features to mark him as a police officer. So any individual on the street could have just assumed he was saying that. So the things could have got a lot worse and got a lot more dangerous with that happening. And that is all I have for you, Your Honor.
All right. Defense counsel, your closing remarks.
Your Honor, it seems to me that the opinion of the Crown Counsel that what differs between a reckless shoot and a good shoot is a matter of clothing. Because it seems to him that if my client here was in his uniform using his service pistol, and like he said in the beginning of his statement there, it was likely going to end up in a shoot anyway. So what's the difference, right? My client, if anything, my client was there in the beginning and was able to neutralize the threat to public safety and to all others heroically, I might add, that my friend, the Crown Attorney, so brought up. And if it weren't for him, there may be other families that have their children that aren't coming home unjustly. But those children weren't robbing a store with a weapon. A weapon, I might add, that the Crown has yet to prove existed on this male. But we know that there was a gun on my client here. So where was the investigative powers of the OPP and the RCMP for the male to show that he as well was a dangerous person? But they're willing to paint my client here a dangerous person just because he's a police officer, which seems to be the way of the media these days. Furthermore,
I'm sorry, defense. Would we be able to pause for a moment? It appears there was someone had gotten a little bit ill here, so we're gonna take a 5-minute recess. All right.
All right. As long as my comments were still on the record there for you.
Yes.
Thank you, sir.
Yes,
yeah,
we will have you
that.
proceed with the rest of your closing argument once we come back from recess.
Yes, sir.
All rise for the Honorable Judge Jason O'Neill.
All right, is everyone ready to go?
Yes, Your Honor. Sorry about the unexpected flight.
Yes, Your Honor.
Not a problem. Defense counsel, you may resume your.
Thank you, Your Honor. Just to pick up from where I left off there, so not only has the Crown not, or the OPP or the RCMP put in the work to investigate the deceased male and the items that he was contained on him, but they sure took all their time to investigate my client here, even though we see him as a hero. And to my friend's point there, that that the deceased male's family have lost a loved one potentially unjustly. Well, I believe my client here is standing trial unjustly when he was just responding as even if he was a citizen to a call for help. He heard gunshots. You know, he ran in to help. He used his training. You know, that's not very just to him, and he very well could have been a victim, and his family could have lost somebody unjustly, or the armed person in there could have lost somebody unjustly. You know, they could have killed somebody, and that family would have lost them unjustly. Just to conclude here, I don't feel that the Crown has done enough to prove beyond a reasonable doubt that my client is guilty of manslaughter, reduced or not. They have not proven that he transported weapons or ammunition due to the fact that they could not come up with the reasonable report on the search of his vehicle. We do concede that the weapon was prohibited, but that is the only charge that we feel that the Crown has filed here that could potentially be litigated. The rest of them are just, I believe, should be thrown out due to the fact that they have not been investigated thoroughly and there is not enough evidence to support the charges. That'll be all, Your Honor.
All right. Thank you very much for your statements. I do not believe that your client acted in a heroic or noble way during his actions of this incident. The proper action for him to have taken would have been to call 911. And after hearing from Crown Counsel and Defense Counsel, I've found this to be a very unique case, and that I have found no similar circumstances of this type which have happened in Canada. I find the details of this case to be very disappointing and questionable as to your conduct on the 12th of September of this year. I find myself questioning this is a failure of your understanding of the law and your limitations as an off-duty peace officer, a failure of training within the Ontario Provincial Police, or a combination thereof. Regardless of which, there was a clear lapse of judgment on the part of Mr. Hillenbrand on the handling of the situation that he found himself in and had injected himself into. As a peace officer, Mr. Hillenbrand had the opportunity to observe the situation and conduct a Provincial Communications Centre, giving a higher level of detail for on-duty peace officers to attend the scene. Unfortunately, we will never know if there may have been a different outcome and how the situation may have unfolded if on-duty members arrived and Mr. Hillenbrand chose not to use his personal firearm. However, this case is not before the court to determine the possible outcomes. We are here today to determine if Mr. Hillenbrand's actions constitute criminal offences. Mr. Hillenbrand, I will now read each offense to which you have been accused, the definition of the offense, the type of offense to which you are charged, my verdict on the offense, and if applicable, my sentence on each offense to which I have found you guilty. Do you understand this, sir?
I guess, Your Honor.
All right. So under Section 86, subsection 1 of the Criminal Code of Canada, titled Careless Use of a Firearm, reads, every person who commits an offense who, without lawful excuse, uses, carries, handles, ships, transports, or stores a firearm, a prohibited weapon, a restricted weapon, a prohibited device, or any ammunition, or prohibited ammunition in a careless manner, with or without reasonable precaution, or without reasonable precautions for the safety of other persons. So, under the indictable offense of careless use of a firearm, I do find you guilty. The reason for this finding is that, based on the testimony of the security footage, I do believe that you would not have had proper time to adequately have unlocked 2 separate cases from inside of your vehicle, loaded the ammunition into your weapon, and took your weapon up to the store, walked inside, and fired it. So I believe with this that you were carrying it in an unsafe manner. So every person who commits an offense under subsection 1 is guilty of an indictable offense and liable to imprisonment. In the case of a first offense, for a term not exceeding 2 years. On this matter, I'm going to be sentencing you to 6 months. Under Section 86, subsection 2 of the Criminal Code of Canada, titled Contravention of Storage Regulations, reads, every person commits an offense who contravenes a regulation made under paragraph 117H of the Firearms Act respecting the storage, handling, and transportation, shipping, display, advertising, and mail-order sales of firearms and restricted weapons. On this charge of indictment, I do find you guilty. As again, this goes towards the storage of your firearm. I do not believe within that time that you did have it stored properly, sir. Every person who commits an offense under subsection 2 is guilty of an indictable offense and liable to imprisonment. In the case of a first offense for a term not exceeding 2 years, I'm going to be sentencing you to 6 months to run consecutively with the first charge. Under Section 87, subsection 1 of the Criminal Code of Canada, titled Pointing a Firearm, reads, every person commits an offense who without lawful excuse points a firearm at another person, whether the firearm is loaded or unloaded. On the indictable offense, I do find you guilty. My reasoning for this is that you did do exactly what the definition of this code says, which is pointing a firearm without a lawful excuse. As you were an off-duty peace officer, not an on-duty one, did not have an on-duty weapon, I do find that you did not have a lawful reason to be pointing that. I don't believe that you were in danger yourself, except for when you injected yourself into that situation. And that if you had have just called 911 and awaited additional officer response, you wouldn't have been in a life-threatening situation for yourself. Punishment for this is every person who commits an offense under subsection 1 is guilty of an indictable offense and liable to imprisonment for a term not exceeding 5 years. On this charge, sir, I am going to be sentencing you to 2 years in prison, to run concurrently with the first 2 charges. Under Section 95, subsection 1 of the Criminal Code of Canada, titled Possession of Prohibited or Restricted Firearm with Ammunition, reads, every person who commits an offense who, in any place, possesses a loaded prohibited firearm or restricted firearm, or an unloaded prohibited firearm or restricted firearm with a readily accessible ammunition that is capable of being discharged in the firearm, with the holder of the firearm, without being the holder of an authorized an authorization or a license under which the person may possess the firearm in that place, and the registrant certificate for the firearm. Under this indictable offense, I find you guilty, as you did have a loaded firearm in a place that you should not have had it, and you did not have authorization to have it in this place. Punishment for this is every person who commits an offense under subsection 1 is guilty of an indictable offense and liable to imprisonment for a term not exceeding 10 years. The sentence that I'm going to set for you in this matter is going to be 2 years to run concurrently with the first 4 charges. Under Section 267 of the Criminal Code of Canada, titled Assault with a Weapon or Causing Bodily Harm, reads, every person is guilty of an indictable offense and liable to imprisonment for a term not more than 10 years, or is guilty of an offense punishable on summary conviction, who in committing an assault carries or uses or threatens to use a weapon or an intimidation thereof, causes bodily harm to the complainant, or chokes, suffocates, or strangles the complainant. Under the indictable offense, I find you not guilty on this charge, as I believe that once you had injected yourself into that situation and were no longer able to leave it, that you were in threat for your life. Under Section 232, subsection 1 of the Criminal Code of Canada, titled Murder Reduced to Manslaughter, reads, culpable homicide that otherwise would be murder may be reduced to manslaughter if the person who commits it did so in the heat of passion caused by sudden provocation. There's a marginal note in here, which is, what is provocation? Conduct of the victim that would constitute an indictable offense under this act that is punishable by 5 or more years of imprisonment, and that is of such natures as to be sufficient to deprive an ordinary person of the power of self-control, is provocation for the purposes of this section if the accused acted on it on the sudden and before there was time for their passion to be cooled. Another marginal note here, which is questions of fact. For the purpose of this section, the questions: A, whether the conduct of the victim amounted to provocation under subsection 2, and B, whether the accused was deprived of the power of self-control by the provocation that he alleges he received, are questions of fact, but no one shall be deemed to have given provocation to another by doing anything that he had a legal right to do, or by doing anything that the accused incited him to do in order to provide the accused with an excuse for causing death or bodily harm to any human being. Under the indictable offense, I do find you guilty on this charge. I do believe that you had put yourself into a situation in which caused you to take the life of another human being, but I do believe that the actions of the individual that you killed did provide the provocation in order to cause the death. On this charge, you are going to be sentenced to 5 years to be conserved consecutively with your other charges. That is going to be all for this matter. Special Constable Rogers, if you could take the defendant into custody, please. Alright, that is going to be all for this matter. Thank you everyone for attending. Crown Counsel, thank you for your time here today.
Thank you, Your Honor.
Thank you, Your Honor.